introduce the king. So, my Lord, in fact, the letter of the 11th of May is a further reason why, tested against the requirements of administrative justice, the meeting of the 14th of May fails dismally. And viewed from the perspective of the wording of Padja, the decision taken at the meeting was not rationally connected to the information before the meeting. Irrelevant considerations were taken into account, and relevant considerations were not considered. Irrelevant considerations, the wrong impression that he had renounced the position. Relevant considerations, that he would have accepted the position if nominated. And no rational connection with the information before the meeting. It's a wrong interpretation of the letter before the meeting. So, Lord, we say on that basis, too, the meeting of the 14th of May must fail. The next question, Lord, is, was the body that assembled on the 14th of May 2021 the royal family? Lord, we say that the answer to this question is a firm no. You can start in the founding affidavit at paragraph 128.2. It's at 002-62. Paragraph 128.2. And again, Lord, this is subject to a striking out application, but I don't understand why it's subject to a striking out application.
So the point is 128.2, not the first part that they were a partner from the late Prince and called it, and not necessarily that there were people who were not royal family members, but the point which you and I understand the other applicant wants to make, important family members were excluded.
Indeed, there are a couple of points, Lord, and this is that important. Indeed, important people were excluded. Lord, I'm not referring to Prince Buthelezi had no authority under statute, because our position for Prince Simakade is that without entering into the status of Prince Buthelezi, we can persuade you.
128.1 might not be, but he called it, and everyone responded.
Indeed,
that,
Lord.
that he had telephone.
Indeed, Lord.
So that 128.2, whether there are people who are not royal
So
family members, I think might just have been a consequence of the other nature of the preceding part of the meeting, the cleansing ceremony. But the point actually I think that you want to rely on is that important family members were excluded. So that's what the decision should be.
26 people missing, and two are expressly recorded. That's Princess Tembi and Prince Mbonisi. Well, they are quintessentially important people. And even in respect of those two, if they're not present, what you say is, hang on, people, there are some important people who should be here who've said they can't make it. It's important that we bring them on board. Let's adjourn this meeting, let's get everybody together, and let's thrash this thing out.
And let me understand the rest of that paragraph in as well, and Prince Simakade's attack. The royal family and the core customary institution, the immediate relatives, is his case also that means the brothers and the sisters of the late Zulu?
No, my Lord. In fairness, I have to concede that if one examines the affidavits, the Prince Simakade and his affidavits don't clarify sufficiently their own position on the papers. So I'm hamstrung by not having a sufficient.
Saying, look, this is the core family. This is what
they are. What we do say, with all due respect to my learned friend, is that he gets the statute wrong. He says you've got the core part of it is the ruling family, and that predominantly seems to be the brothers and the one sister who isn't married. That's the ruling family, and then the royal family is something wider than that. We say that on a proper interpretation of the definition in Section 1, and perhaps just to make it easier, we can go there, my Lord. It's in that bundle of authorities. at page 069-26.
And why I ask is the allegations made, look, 26 people who were supposed to be there wasn't there. Now, how does one determine whether that is correct and what was supposed to be there? Who should have?
Lord, the way that we've approached it for purposes of this argument is to accept the second respondent's version, which is that you take the last 5 kings, and it's their descendants. That's the basis that we've used for analysis.
That will be wider than just the brothers and the sisters of the
Indeed,
nation.
Lord.
It will include more.
Indeed, my Lord. For purposes of our argument, we will assume the correctness of that position. Frankly, my Lord, that's part of the reason why we do not favour a remittal to the royal family. It's very difficult to work out exactly what it is, and it's going to be a source of further disputation. But, Lord, at the very least, there were 2 very important people who were left out. We say, in addition, 26 people were left out. We also, the court will bear with me for a moment. Sorry, my Lord, just to pause at the strikeout application where I was. There's an attempt to strike out that application, but it's made on the basis, I think, of a mistake, that we didn't confirm it. But there are 2 confirmatory witnesses for the meeting of 14th of May supporting Prince Simakade. But, Lord, to some extent it doesn't matter too much, because there are other problems in relation to the constitution of that body. Lord, there is a list that appears at 002-93. And that list, my Lord, that's in paragraph 2.
There were a number of other people who attended the meeting who in fact are not related to members of the royal family. Despite this, their name appears.
Indeed, my Lord.
This was in complete breach of customary law. They should not have been allowed into any meeting.
Indeed, my Lord. And those are then listed. Now, Lord, those paragraphs are denied by Prince Misuzulu at paragraph 23.4, 05279. To save time, I won't go there, but our submission in relation to paragraph 23.4, page 052-79 of Prince Mboni's affidavit is that is a bare denial. It doesn't provide an adequate dispute of that. There is also a strikeout application in respect of paragraph 206 on the basis that insufficient information is provided in relation to those names.
Yes, but now you see, now again, a difficulty with the version. So let me just understand. So Prince Simakade says, look, these members, these other listed attendees, these 10 should not have been there. And then he says the next point is, none of these individuals should have been included in the meeting, and the fact that they were not only present but vocal and persuasive renders the meeting unlawful. But early on in his affidavit says that no one said anything. Was that not so?
Sorry, my Lord,
Didn't he earlier in his affidavit say that at the meeting no one said anything?
my Lord, I'm not sure if I'm following, but the point here is viewing it retrospectively. These are people who, from that attendance register,
Yes.
were there and shouldn't have been participating.
My question was, but is his paragraph 207 then correct? Is the point only that they were there, they shouldn't have been there? But 207, didn't he earlier on in his affidavit say, look, at the meeting, only the late Prince Buthelezi spoke and no one else spoke?
Indeed, my Lord.
Right, so
You're saying because nobody spoke, it doesn't.
how can you then say that they were vocal and persuasive members that renders the meeting unlawful?
No, but we didn't say that nobody. We didn't say that nobody spoke at that meeting. We said nobody was allowed to speak at the 7th of May meeting. The 14th of May meeting, people were indeed allowed to speak,
All right.
but we say they spoke in circumstances where he'd already been introduced as the king, and all they essentially did was to say rah rah. Now, I'm not. There's an attempt to strike out paragraph 206 on the basis that there's insufficient particularity. But Lord, the reason that doesn't withstand scrutiny is that there's an impermissible late affidavit put up by Prince Tulani, in which he, by the second respondent, and we're going to seek it striking out, but what it demonstrates is that he was able to identify all of these people, had no difficulty. And then he comes up, and I'll give your lordship the reference to that affidavit in a moment. But he then comes up with this highly implausible excuse that he says, yeah, well, no, some of these people signed because I asked them to lift the flaps of the tent, and by mistake they signed the register, and some people were indunas or people who were allowed to be there, and by mistake they signed their attendance register. Just, even if that affidavit is to be admitted, it isn't a satisfactory answer. But what it does answer is that people know exactly who we're talking about here when we say this. There's plenty of particularity. But Lord,
it would be highly surprising if someone doesn't know who the chairman of the Ngonyama Trust was.
Indeed, Lord. Now, in fairness to the second respondent, they do say excluding the chairman of the Ngonyama Trust. I must point that out, and they say the same in respect of the church members there. It's in respect of the other names, and in fact, the strikeout doesn't apply to 1 to 4. But Lord, the real problems come later on. Lord, in the answering affidavit of Prince Misuzulu, he puts up a tight attendance register about which there were submissions this morning. Now, we're prepared to take that kind of at its face, subject to the submissions that I will make. Because what Prince Simakade does then in reply to Prince Misuzulu's answering affidavit is he points out a number of further attendees who were not part of the royal family. And that appears, my lord, and I'll come back to it at paragraph 70 and following of the replying affidavit of Prince Simakade to Prince Misuzulu. But before I go there, what Prince Simakade does there is he says, take the second respondent's hypothesis of the last 5 kings. The last 5 kings, and just to give your lordship the reference there's a family tree, and perhaps we should have a quick look at it. There is a family tree at page 002-37.
It's a very well-known family tree.
Very well known indeed, my lord, and famous all the way through. So, my lord, the family tree starts all the way back with Nguni, includes Shaka, and however, what the second those are the last 5. What that means, my lord, is that if somebody is a brother or a sister of King Ketshwayo, they are not included. And then the same going back, if somebody is a brother or a sister of King Mpande, they are not included, and so on. And that's the basis that is used, which is an entirely fair basis, given that it's second respondent's case. That is then used by Prince Simakade to analyze that typed list. And then if we can go then to 054-37. Paragraph 70. Further, many persons purporting to be members of the Zulu royal family who attended and participated in the identification of the second respondent were disqualified from attending and participating in terms of the second respondent's own definition of who forms part of the Zulu royal family for the purposes of an identification of an heir. And then, if we go down to paragraph 71, indeed, an analysis of the attendees reveals a number of errors and misrepresentations of lineages of the attendees. At paragraph 712, the second respondent asserts that the houses of the Zulu royal family, which are central to the decision-making processes of the identification of the successor to the late king and form part of the royal family of the preceding kings, are those from, and there they give the version. However, the attendance registers annexed by the second respondent whose answering affidavit reveal that many of the attendees at the meeting of 14 May misrepresented their lineages, including Prince Buthelezi. This manipulation of lineages had the effect of purportedly bringing within the fold many members who ought to have been excluded from the royal family's deliberations. These members ought not to have participated in the decision-making process of the identification of the successor. Scrutiny of the transcribed attendance registers forming annexes to the second respondent's answering affidavit yields the following. Misrepresentation of lineages in Annexure KM9, appearing at 2 as Prince Buthelezi, whose actual lineage is King Dinizulu, but misrepresented as being of the lineage of King Solomon. And that's quite correct. And my understanding, if I'm correct, is that Prince Buthelezi's mother was the sister of King Dinizulu. The sister or the daughter, I speak subject to correction, but either one of those would not make it a lineage of King Solomon. Appearing at 8, Princess Phumzile is the daughter of Prince Buthelezi. She is misrepresented as belonging to KwaKhangela Palace, the same palace as the second respondent, and in fact Prince Simakade, when in fact she is of Kwapindan, I don't know if this is correctly spelled here, Kwapindangeni, I think it is, royal residence. Further, she is misrepresented as the daughter of the late Asilo in order to bring her within the fold of the royal family. As a daughter to the princess's son, she does not fall within the fold. Appearing at 9 is Prince Mtokozini Mahlobo, misrepresented as being of Kwapindangeni royal residence and not of King Solomon's lineage. His actual lineage and palace are King Bekuzulu and Kwaketum Tandayo. As the son to the princess, he qualifies. And Lord, one can see the honesty of this analysis because even where people misrepresent their lineages, if they in fact do belong within the family, he says, fine, I'll accept that. And so he goes on. He works through all of them, and I won't go through all of them, but the list just grows and grows of people who should not have been there as one moves on down through the paragraphs. Paragraph 71.5. Again, where a person belongs, such as 71.5.1, he acknowledges it. Where a person doesn't, he flags it, and one sees the numbers increasing as one goes along. Paragraph 72 on page 054-44. Moreover, the attendance register records a number of attendees who do not fall within the fold as identified by the second respondent himself. In this regard, paragraph 7.13, the second respondent asserts the only other houses allowed to attend as extended members of the royal family, although their attendance is not central to the decision-making process and they do not form part of the core structure of the Zulu royal family, are the Royal House of Jama, the Royal House of Zibebu, and the Royal House of Mpande. Now, the definition of royal family does not allow extended family members. It uses the word immediate and it uses the word close. So again, they're problematic attendees. So if one then goes to paragraph 73.2 on page 05445, the numbers are huge. Appearing at 1, 2, etc., a large number of people are attendees from the house of Egazini, the descendants of King Ndaba, who are therefore not within the fold. And it's correct, one can see from the family tree ourselves that they're not within the fold. And he then concludes at 74, having regard to the above, it is clear that the majority of the attendees who attended and participated in the portrait identification meeting of the second respondent are not qualifying members of the Zulu royal family as defined by the second respondent himself and or as set out in the Leadership Act. And Lord, that really is the end of the meeting of the 14th of May. And we know that there's no answer to that, because in this illegitimate attempt to pile further paper into this application that comes after the specified date for the answering affidavit and the heads of argument, the only thing that's put up is the Prince Tulani affidavit that I referred to, where Prince Tulani deals with that initial list in paragraph 206. There's a complete silence as far as this is concerned. So we can tell from that, had they been given the opportunity, had they had a response, they would have had something to say. There's a deathly silence as far as this part of Prince Simakade's replying affidavit is concerned. Now, Lord, this issue was dealt with in the Impepu judgment in paragraph 38. And if I could just refer your Lordship to that. That's at 069-766. There the court said, talking about the Mpepu situation, there were members of the Royal Council present in the meeting. The Royal Tribal Council is an administrative structure established in terms of the Framework Act, and some of its members would also be members of a royal family. The persons who serve as both the royal family and the Royal Council are entitled to attend and participate in the royal family meetings. However, the members of the Royal Council who were not related to the Mpepu Ramabulana royal family were not entitled to attend the meeting of 14 August. The eighth respondent itself confirmed in its affidavit that the meeting was also attended by other senior traditional leaders who are members of the Royal Council, but not of the Mpepu Ramabulana royal family. Thus, the decision to identify the king of the Vivenda was not taken by the royal family only, as required by customary law custom and the Framework Act. It was taken by a joint sitting of the royal family and the Royal Council. The decision of the meeting was thus not in accordance with the law. It stands to be reviewed and set aside in terms of 6282 of Pudja. This is so because the decision was taken under a delegation of power which was not authorized by the empowering provision. In terms of 62B of Pudja, in that a mandatory material procedure prescribing an empowering provision was not complied with, and in terms of 62E4, in that the action was taken because of the unauthorized dictates of another person. The High Court erred in dismissing this point in limine. So, yes, we haven't got a Royal Council situation here, but we have a whole massive group of people who weren't entitled to attend. Lord, so the 14th meeting fails. There is a faint attempt to rely on a meeting held at Ulundi on the 29th of September 2021, but it suffers from the same flaws and more of the meeting of the 14th of May. The President seems to quite like this meeting of the 29th of September. There's also a peripheral reliance on it by the second respondent. Lord, that meeting was held after the 90-day period provided for in Section 81A. By that time, we submit there was a firm divide within the royal family, and obviously members of the pro-Simakade grouping were neither welcome nor inclined to attend. The minutes record an introductory speech by Prince Buthelezi before resolutions were taken, in which he again introduces Prince Misuzulu as king. Indeed, he confirms in his speech extraordinarily that the meeting was convened by the king. And I'll take your lordship to the references. But Lord, a purportedly standing king can never provide the unbiased impetus for a fair identification meeting. There is no reason to believe that the attendance of the meeting was not as flawed as the preceding one in relation to who was present. And certainly there is no recorded attempt to isolate at the meeting those persons that fit in with the second respondent's version of the royal family. Lord, that your lordship will find at 020-204. (020-204) is where the minutes start, and there's a reference there to that's where the speech in fact starts. The resolutions that were taken after the speech appear on the preceding pages from 020-202. But the important part for present purposes, my lord, is at page 020-210. At the end of Prince Buthelesi's speech, where he says this meeting was convened by the king, backed up by his Queen Mother Mazungu and Prince Philemon of Fihlengendi and myself. As has been my duty for some 60 years, I'm honored now to introduce His Majesty our King, so that he may give us guidance in this painful moment for the royal family. Lord, that, with respect, is only, the problem is only enhanced. How can one of the candidates run the process? Just simply doesn't work when tested against the requirements of administrative law. How can we suggest that King Misuzulu wasn't in favor of King Misuzulu and was going to run that meeting in an appropriately unbiased way? So, Lord, we say that meeting also doesn't save the identification process. And I'll come back to that letter. In fact, sorry, that minute. Within that minute are also the seeds of the destruction, some of the many seeds of the destruction of the recognition decision, because it's awash with references to the dispute. So, my Lord, our conclusion then on the identification decision is that there was no constitutionally or statutorily compliant identification decision. We set out the review grounds in paragraphs 129 to 142 of our initial heads. And Lord, we say that I'll come to the implications of that as far as the recognition decision is concerned. If I can then move to the recognition decision, that completes the submissions on the identification decision. As far as the recognition decision is concerned, a preliminary point, my Lord, and that is that the President was requested by Prince Simakade's attorneys in writing, in terms of Section 5.1 of Pudget, to provide reasons for his recognition decision. Lord, the reference for that, you needn't go there, my Lord, is the founding affidavit at paragraph 8, 002-16. I don't think it's recorded in our heads of argument. So paragraph 8, 002-16. And Section 33.2 of the Constitution, read with Section 5.1 and 2 of Pudget, obliged the President to provide those reasons within 90 days. He failed to do so. That means that Section 5, subsection 3 of Pudget kicks in. And that reads, if an administrator fails to furnish adequate reasons for an administrative action, it must, subject to subsection 4, and in the absence of proof to the contrary, be presumed in any proceedings for judicial review that the administrative action was taken without good reason. So, my Lord, we say that that kicks in here. It effectively places the onus squarely on the President to justify the recognition decision. But we make the further submission, my Lord, that even if your Lordship disregards that onus provision, it's quite abundantly clear on the record that the recognition decision doesn't withstand scrutiny. Lord, it's also an illustration of why one cannot apply res judicata in respect of what happened in front of His Lordship Mr. Justice Madondo, because it accentuates the difference between the two sets of proceedings. We're dealing here with the judicial review, with its own statutory rules, its own presumptions. What happened in the judgment that is relied on by the second respondent and the first respondent, it was an application for interim relief. Prima facie right, though open to some doubt, is how it should have been adjudicated, and we'll come to that. In fact, it was wrongly adjudicated on the basis of Plascon. But the two processes just differ completely. Lord, if I can then come to why we say it is beyond...
Well, it goes also a bit further than that. For Zondo AJP, there was no recognition decision yet, and no publication thereof. So there couldn't have been a review of that. It was just the interim application to prevent the assumed date of 3 December 2022 for coronation.
Indeed, my Lord. And it's your Lordship's point is specifically made by Justice Madondo himself. He says the review is for another day. And if you look at the wording that he uses, it's clear that in referring to the review, he's talking about a review of both the identification and the recognition decision. But as he also correctly points out, based on Mpepu, you can't jump the gun. You've got to wait for the recognition decision to come before you can start reviewing the identification decision. And that's why it would be so terribly unfair to Prince Simakade if that judgment were to be held against him. But Lord, the interesting thing is that the judgment itself confirms that there was a dispute, as envisaged in both 8.4 and Section 59. If I can just quickly take your Lordship to those references. In the judgment, indeed, Lord. And that's at 020-155, 020-155.
Give me the paragraph number in the judgment as well, please.
Lord, I think the first reference is at paragraph 57. Paragraph 57 of the judgment. We're now in the preceding case involving the disputed will.
Yeah.
And this is just to make the very simple point of evidence of a dispute. So paragraph 57, the applicant has failed to establish a discernible correlation between the proceedings relating to the impeachment of the late Isilo's will and the dispute relating to the alleged identification and nomination of Prince Misuzulu as the successor to the Zulu throne of the royal family. So there you have both an 8-4 dispute and a Section 59 dispute.
Now in 60 it says the impeachment of the late Isilo's will has no bearing whatsoever on the succession dispute. That's in paragraph 60.
Indeed, my lord. And
he says there's no dispute for the Premier or the President to investigate. So there's no 8-4.
So he contradicts himself in that regard, my lord. That's the reality of it.
Even 57 and 60.
But perhaps I should just, rather than labouring my way through them, just give the paragraphs that we rely on, my lord. So it's 57, 60, 76, 80, and 95. So we say one can just as easily rely on the judgment to justify an intervention in terms of Section 8.4. And one cannot rely on it to, we submit, do the reverse. So even if we take it on, even if your lordship was somehow bound by it, your lordship would have to take that into account. And of course we say your lordship is by no stretch of the imagination bound by that judgment. Lord, the instances of evidence and allegations of non-compliance with customary law and custom and of the existence of a traditional leadership dispute are set out in our initial heads of argument, and I'm not going to go through all of these. If I can perhaps just give your lordship the references. It's paragraphs 94 to 128, and it's at 031-59 to 031-75. But just to touch on a couple of the main ones. Lord, there is a.
Talking about the meeting of the 14th of May. Yes.
Sorry, my lord, you've lost me for a moment.
Sorry. You're referring to paragraph?
No, I'm referring to the. So I'm referring to. What I want to take your lordship through is a few of the main items of evidence and allegations, as it were, or evidence of a dispute. And my starting point is the letter of the 28th of May, 2021. That's Annexure SZ10 at 002-234. Now, my lord, that's an appallingly bad copy of a letter, for which I apologize, my lord. But one can still discern from that messy typing that there is quite clearly compliance with Section 8.4 and 59. So if we look at that heading on page 002-235, it says, letter disputing all processes relating to the nomination and or pending recognition of His Royal Highness Prince Misuzulu as the King of the Zulu Nation, lodged in terms of Chapter 5 of Section 59, read together with Section 8 and 1 of the Traditional and Khoisan Leadership Act of 019. Oh, fantastic. Lord, my junior counsel has produced a miracle, which is a clear copy of I'm told it's my attorney, not junior counsel, but I'm happy to credit both of them. Which is a clear copy, if I may beg leave to hand that up. But more to try and speed things up, I won't take your lordship to all of it. What I will simply then do is to point out, as it were, the headings that come. So I've read to your lordship the heading. What it does, it provides firstly a lengthy and detailed analysis of the relevant legislation over some 14 pages. It then examines customary law and case law in this regard, including constitutional case law with extensive quotes from the Constitutional Court decision in Shilubana. References also made to the Constitutional Court judgment in Alex Corps. The letter deals with the hereditary law of succession in detail and at length. The letter deals with the custom of ukufakwe eseswini, again at length and in detail. It deals with the alleged position of traditional prime minister and customary law in this regard. It deals with the facts and the legal framework in context. It deals with the meeting of the 7th of May, and it deals with the meeting of the 14th of May. My Lord, how can it possibly be said in the face of that voluminous document, I think it's some 88 pages in length, that there was not a dispute that was drawn to the attention of the President? Or even an allegation, my Lord. That's all that's required is an allegation. Well, there you have it. One need go no further than the heading to know that there's an allegation. And it links back all the time to non-compliance with customary law. That's exactly what the President, that's exactly the circumstance in which the President is required to intervene. Now, Lord, an important consideration in relation to that letter is that it is not dealt with at all by Madondo AJP. So even if Madondo AJP, and if your Lordship was to be persuaded that his judgment binds you in relation to Prince Tembi's letter of the 3rd of June, it doesn't say anything about that letter. The Lordship is free to draw your Lordship's own conclusions as far as that letter is concerned. Now, I must immediately add that the President claims not to have received that letter because he says there is no record of it. Lord, I think that is at paragraph 134, 029-47 of his affidavit. We needn't go there, my Lord, because I've said what it says, that he's got no record of it, so he says he didn't receive it. But, Lord, the following submissions are made in response to that contention. Firstly, it is common cause that the letter was sent to the Premier. Lordship will see that it's addressed to both of them. The second respondent specifically asserts and complains that the letter was in fact sent to the Premier. In terms of Section 8.1b, the President's recognition decision is meant to be taken in consultation with the Premier and the Minister. Given the substance of that letter, which is quite something, if the President consulted the Premier, he must have discussed that letter with him. How could they possibly not have done so? The President, being a lawyer himself, would have been suitably impressed by it. If he did not discuss it with the Premier, then it was an abortive consultation. Of course they should have discussed it. And if they didn't discuss it, it renders his decision invalid, his recognition decision invalid. If he did not consult with the Premier, then on that basis too, the recognition decision is abortive and invalid. In any event, the letter sent by Princess Tembi on the 3rd of June makes express reference to the letter of the 28th of May. If I can refer your Lordship to page Annexure SZ14 at 002-322.
Sorry, her letter is dated?
Her letter is dated the 3rd of June, Princess Tembi's. And the reference, that's at SZ14, and the reference is 002-322.
She makes reference to this letter.
And she makes reference to that letter, my Lord. Sorry. And it wasn't, and it was, my junior counsel pointed out, it was in fact annexed to that letter. So how it hasn't found its way into the record, I do not know, my Lord. Now, my Lord, if somehow it wasn't attached, the moment he saw a reference to it, he ought at the very least If, say, by the time it got to him, somebody had pulled it off or left it behind or something like that, the moment he saw a reference to it, he must have realized that it related to this burning dispute. And he should have said, I want to see everything. That's my job in this position where I make this assessment. Bring it to me. So, whichever way you slice it, it's going to lead to the invalidity of the recognition decision, based on that letter alone of the 28th of May. What also tends to contradict the President's averment that he did not receive the letter is that there are 2 copies of the minutes of the meeting of the 5th of May in the Rule 53 record. And it was the letter of the 28th of May that attached the 5th of May minutes as one of its annexes. Then, my Lord, if one works one's way through the letter of the 3rd of June, subject to the debate about res judicata, again, it is just beyond cavil that there was a dispute that required intervention in terms of 84 and 59. Again, her heading on page 002-322, dispute of the royal family in terms of chapter 5, section 59, read together with section 8 and 12 of the Traditional and Khoisan Leadership Act 3 of 2019. In a way, one need go no further. But if one then looks at the contents page, these were beautifully presented letters that were sent to the President. There's a contents page in which he sets out introduction, legislative framework, again, the Constitution, hereditary succession, the position of the great wife, the custom of ukufakwa, the senior prince, the office of the traditional prime minister, facts and legal framework and context, recognition of a regent. Indeed, my Lord, on page 002-3324. All the customary issues relating to the identification process, the controversial identification process that took place. So, my Lord, again, this letter on its own is another bullet hole through the recognition decision. And, Lord, we deal with it also. I won't go through it any further, but we deal with it further in the initial heads at paragraphs 98 to 103. Lord, the second respondent and Prince Mbonise, with respect to the eternal discredit, question the late Princess Tembi's entitlement to get involved in this sort of thing on the basis that she is a married woman. Lord, one need say no more than, really, this in a 30-year-old constitutional democracy that prides itself on the strides towards gender equality. Lord, if we can then move to the mediation panel, and my learned friend has dealt with it quite extensively, so I won't spend long on it. But the existence of evidence and allegations of non-compliant identification and a traditional leadership dispute is abundantly clear from both the conduct and the communications of the President in this regard. This is particularly so around his request to the Minister of Cogta to intervene, which led to the establishment of the mediation panel. That's the letter of the 16th of August that my learned friend has already taken your Lordship to. All over it, every single paragraph alludes to the existence of a dispute.
Yes, well, we've also seen the report.
Indeed,
and
Lord.
then the conclusion, paragraph 6 and 7.
Indeed,
and
Lord.
the medium of long-term proposal.
Indeed, Lord. And one has to ask the question,
Why is it,
what does a mediator do? They settle disputes. That's why you bring them in. Some Lord, really. But one aspect that's particularly problematic, to put it delicately, for the President is that they specifically say that he must appoint an investigative committee. They say that in writing, and they tell him to do it. I'm just struggling momentarily in my notes to find the reference for that. That, my Lord, I've got the reference. It's at page 020-87. paragraph 11.5. Appointment of investigating team per legislation. It is deemed by us as the panel that before the President implements any person, he ought to first investigate through a legally formed investigation team. Issues to be investigated must include whether Prince Simakade and Ilibomvu is true, as well as his institution into the Kangela, it should say Kangela Mankengane Palace. If true, can it be undone or overlooked when the appointment is made? Remembering that Queen Mantfombi is known to have tried to persuade the installer, the king, but only managed to add 8.4 is more specific to the process of things going awry after the identification or in the course of the identification process. But again, my Lord, we emphasize in relation to both Section 59 and Section 8.4, as my learned friend pointed out, a very low threshold before the President's peremptory obligations kick in.
Yes, that's what you also argue, that it's mandatory.
And it is indeed mandatory, my Lord. Well, just by way of a brief preliminary point, the second respondent's heads of argument suggests that the two cases before the court have been consolidated, Prince Mbonisi's and Prince Simakade's. That is not correct. The directive of the Deputy Judge President was effectively that the two cases be heard together. There has never been an order of consolidation of the cases. And
does it make any practical difference?
Indeed, my Lord, the evidential wall between the two cases, as a result, we would submit needs to be respected. So that if Prince Simakade is able to make out a case on his papers before the court, he is entitled to relief, notwithstanding any difficulties that might be confronted by Prince Mbonisi in his application, we would submit.
No, sure, but if there's consolidation, then either or both of the applicants might succeed. I hear you say there's a potential wall, but
at the end of the day, it may have no particularly significant consequence. And my sense is, just to raise it as a caution, I haven't come across anything to suggest that reference to Prince Mbonisi's case should give rise to any downfall of Prince Simakade's matter. Well, if I can then turn to the identification decision. Well, the identification decision, which was essentially, if one looks at it, what's relied on by the second respondent is the decision of the 14th of May 2021. This was preceded by a sequence of events. These are set out in Prince Simakade's founding affidavit at paragraphs 99 to 126, commencing from page 002-52. I won't take the court there. Those are not, as we read it, essentially contested by Prince Misuzulu or Prince Mbonisi, except for the 5 May meeting, and of course except for the 14th of May meeting itself. There is a strikeout in respect of some of those paragraphs, which to the extent necessary we will deal with. But essentially what is encapsulated there is that the
May meeting chronologically just reminds me that took place before the reading of the late Queen's will.
Indeed, 2 days before, my Lord. But its significance is now substantially diminished by the fact that we aren't pursuing substitution.
Yeah.
If we were pursuing substitution, it would obviously have to come into consideration.
Yes. So 14 May.
So 14 May, there's obviously some disputation, but just to quickly recap the sequence of events, the king dies on the 12th of March. This gave rise, if one is to observe the 90-day period, to a need to identify his successor by the 10th of June 2021 on my calculations. The king's will was read out on the 19th of March. He had identified Queen Mantfombi in his will as successor. A meeting took place on the 24th of March to discuss succession. It couldn't reach finality, and that was adjourned for later discussion. Notwithstanding that adjournment, Prince Buthelezi announced to the media at the end of that meeting that Queen Mantfombi would be the regent and not the queen. But as your lordship has pointed out, before anything could happen, Queen Mantfombi passed away on the 29th of April, and then followed the memorial service that was held on the 7th of May 2021 at her palace, KwaKangela Mankengane. There, Prince Buthelezi announced that a meeting would be held that same evening to read the late Queen's will and it was there that the will was read, and it purported to nominate Prince Misuzulu as king. Now, Lord, I understand from my learned friends that the reliance on the will has fallen away. My learned friend for the second respondent. If that is the case, I don't need to, as I understand it, to persuade your lordship of the invalidity of the process whereby Queen Mdntv purported to nominate. The submissions would have been that, yes, there may be a custom that the outgoing king can effectively recommend somebody by document, and it's a strong consideration, as your lordship has pointed out, but there is no custom to...
I don't think it is maybe a custom. I thought that was the custom.
May in the different sense of the word.
Right.
Indeed, Lord.
Yes.
Yes. But what there certainly isn't is a custom to suggest that the king can then delegate to the queen, who can then make an appointment of a particular person. I don't understand that argument to be persisted in, but for safety's sake, let me go to the late king's will, and that's Annexure SZ4.
I understood that wasn't the reliance. The reliance wasn't placed on that anymore.
I think that's correct. But, my lord, just to give you a complete picture, if I may beg leave to hand up a better copy of Annexure SZ4, which starts from 002127. And just to complete the picture, my lord, if one looks at paragraph 16 of the will, clause 16, I should say, on page 002-130, one sees the relevant provision, which says, clause 15 it starts with, as regards my successor to the throne, I hereby nominate and appoint SM Zulu, identity number, that is a reference to Queen Mdntv. And then 16, failing SM Zulu, and 15 above, I hereby nominate and appoint, and it's left blank. So no one was in fact identified in any way, either directly or through any form of delegation provision. But also of possible interest, but we won't rely on it, because we will argue that even if your lordship were to accept that Prince Buthelezi played the role of traditional leader, we still say that the identification decision fails for the reasons that I'll advance. But it is not lacking in interest that clause 18 says the following. I further direct that Sipho Jerome Ngwenya, who's the chairperson, as I understand it, of the Ngonyama Trust, or the administrative body that underlies the trust, or failing such person, the Royal Council referred to herein, appoint a suitably qualified person as a manager and coordinator of all relevant activities, including but not limited to the following: liaising and assisting the executor appointed herein, ensuring that the executor expeditiously progress his/her and finalize his/her mandate without delay, coordinate all the affairs of the entire royal family and ensure that it is kept informed of all developments, be a link among the royal family members, the executor, government, and the royal council, attend to every detail required for the royal family, family's attend to every detail required for the royal family to discharge its duties. Now, I just make the comment in passing that there's nothing on the papers to suggest that Prince Buthelezi did ever comply with any of those requirements in the sense of an appointment as a manager. But, Your Lordship, we didn't take that up in our founding affidavit, and we don't need to rely on it, because we're confident that we can demonstrate to Your Lordship that even if Prince Buthelezi was the Prime Minister, as he says he was, the meeting, as I've said, fails. So, my Lord, if I can start by returning to the sequence of events, and here I would like to refer to the affidavit. That's at page 002-57. From paragraph 117, describes the event starting from the 7th of May meeting. So accordingly, a meeting which was open to the public and screened live on TV was held, and a will was read by one advocate, Griffiths Mdntv SC. Advocate Mdntv informed all present that the late Queen had nominated Prince Misuzulu as the next king of the Zulu nation. This gave rise to a number of queries and concerns as to the legal validity of the Queen's purported nomination and its status. The meeting descended into chaos as Prince Buthelezi denied members of the royal family a chance to ask questions, and police were called upon to remove Prince Thokozani of KwaDlamahlala, although ultimately they did not do so. No one else was allowed to speak in that meeting except for Advocate Mdntv and Prince Buthelezi. Prince Buthelezi announced that the succession debate was closed. The following day, the 8th of May, Prince Buthelezi again addressed the media and reported that the matter of succession had been settled with the reading of the will. And as far as he was concerned, the king is already on the throne. Prince Misuzulu was addressed by Prince Buthelezi as the king and given the Bayete salute that only kings are given. Thereafter, on the 9th of May 21, the Premier of KwaZulu-Natal visited Kwankangela Mankangani Palace, purportedly to pay his homage to the newly announced king. I understand that notwithstanding that there had been no identification decision by the royal family in relation to Prince Misuzulu, the Premier brought cattle with him, which he presented to Prince Misuzulu. On the 10th of May 2021, the KZN Premier spokesperson, Mr. Lennox Mabosa, is quoted by the media as having said that the Premier will announce the date for the coronation of King Misuzulu. Now, Lord, probably because of what then follows in paragraph 121, Prince Simakade says, I was not involved in or consulted about any of the foregoing developments. There is a strikeout application in respect of those paragraphs, or at least from paragraph 118. But we submit that that horse has bolted because those paragraphs were not disputed in the answering affidavit of Prince Misuzulu. If we can then turn to the events of the 14th of May meeting itself.
Well, just assist me with that. On paragraph 117, you read that out, no one else was allowed to speak in that meeting except for Advocate Mdntv and Prince Buthelezi. That is disputed. And doesn't the minute of that meeting indicate there were other comments made as well?
Lord, my reading was confined, I should say, in preparation to perusing the affidavit of Prince Misuzulu, and I didn't read it to dispute those. What I haven't done, and I speak subject to correction, if the minutes contradict that, then I speak subject to correction as far as those are concerned. But the point I'm coming to is that this was a decision that was prejudged. The outcome was prejudged, and there are problems with that. And we submit that that is so on the papers, even if your lordship is ultimately against us as far as that is concerned. Then if one looks at they're essentially the second respondent in Prince Buthelezi's minutes of the 14th of May. And if I can turn to those, we submit that those in any event demonstrate exactly the same point. So, my Lord, if we can just have a look at those again, if your lordship will bear with me in doing so. I think that's at
I follow that because I raised it with Advocate Masuku as well when he said, look, here comes the late Prince Buthelezi, and he says, you know, the king is on the throne and he makes the announcement. But then the minutes seem to suggest that there was some discussion about that later.
Well, Lord, if one looks at the sequence, it starts with the purpose of the meeting.
Yes, it wasn't.
The purpose of the meeting is to introduce the king. The purpose of the meeting is expressly in the minute to introduce the king. And perhaps we can just go there so I can.
I have it at. Is it not 020?
There are a couple of instances of it lying around the record. I'm going for 059-288. Indeed, Lord. There's a better copy. I've just predicted there's a better copy when there isn't. Court will bear with me. Perhaps I can just turn to the page your lordship is on of it.
think I know the Misuzulu one. At 020260.
Yes, my lord. There's one at 002.
In which application?
No, it seems to be missing the first. Page. The court will just bear with me. So, in the record.
020272 is a translation.
026114, my lord.
All right. Right, so then you say the purpose of the meeting is paragraph 4.
So starting at paragraph 1 on page 026114,
Yeah.
minutes of
It
the
starts there for the meeting, for the introduction of the
to introduce the Zulu king. There's no question of a nomination or anything of that sort. And then, purpose of the meeting, Prince Mangosuthu Buthelezi of KwaPindangeni welcomed all the attendees according to their ranks. He was very pleased to see the presence of all royal family members, which assured solidarity. The Prince of KwaPindangeni introduced the nominated new king of the Zulu nation, past tense, the nominated new king of the Zulu nation, to all the royal family members. Prince Misuzulu KwaZulu-Natal Kabeku Zulu. The Prince stated that the President and the government are still going to do the coronation of the king to the throne. The Prince then asked Prince Tulani to please come forward and read a letter from Prince Simakade Zulu attached. Then he says he also raised the name of the nominated one as the king of the Prince, as the king of the Zulu, Prince Misuzulu Zulu. But, my lord, the point we make is by the time he gets there, it's a fait accompli. He's introduced him to the assembled people as the king. So it doesn't help that there's then, after all of that fanfare, an attempt to return to the issue of nomination. And of course, it's quite predictable. Every royal family member that was in attendance at the meeting agreed that he should be appointed. The new king is supported by all the royal family members, not the candidate. The new king is supported by all the royal family members who were present in this meeting. And then if one goes on and reads through all of the comments, there is a complete dearth of any attempt to evaluate, to say what the criteria were. If one looks at the Mpepu judgment, it's a matter in which I was in fact involved. At least there, when the meeting, and there the identification meeting was found to be unlawful, but at least the person who was chairing, Mr. Mpepu, laid down the criteria, 1, 2, 3, 4, 5, 6, for identification. Unfortunately for him, in that particular case, as the sixth criterion, he said only a male can succeed. So that was the seed of the undoing of that identification process. But here we don't even have that. So, Lord, that by way of what took place at the meeting. We say that even on the second respondent's own minutes, it was prejudged. There also, we would submit, was not on the record proper notice of the meeting. Nothing is put up that is suitable as far as that is concerned. There is one late affidavit extracted from the KwaZulu-Natal proceedings by a person who has passed on, and which we in fact seek to strike. But it deals with it very briefly, and perhaps if I can ask your Lordship to turn to that, it's 059-288. It's an affidavit.
So just give me that reference again. Is that in Prince Simakade's application?
Indeed, my Lord. I'll refer only to Prince Simakade's application. It's page 059-288.
Yes.
Well, if one turns the page back, that is the
of Prince Simbogise.
Indeed, my Lord. And he describes how notice was given. He says, I confirm that I was requested by Prince Buthelezi to assist him convene the meeting of 14 May 2021 by informing all the royal houses and members of the royal family. I accordingly telephoned members of the royal family and requested them to make themselves available for purposes of the deliberating on the question of succession. I understand this to be the usual way in which meetings of the royal family are called. Quite an odd final paragraph, because he doesn't seem to be too confident about it. But Lord, there's nothing more that's offered. And we know this must have come after the meeting of the 7th of May. So within 7 days, he claims to have telephoned more than 140 people, but offers no record of it. We live in an age, Lord, where everything of this nature is recorded on cell phones and so on. Nothing is put up to show that there was a proper notice of the meeting. How are we to believe him?
All right, but how far does that argument go?
Well,
it's almost like someone saying, but you didn't comply with service, but here I am.
Lord, how far it goes is that there were people missing, important people missing from that meeting.
No, that's the point, yes, to say, well, insofar as there has been an invitation extended, it wasn't to everyone.
Indeed.
Is that the point?
Indeed, my Lord, and wasn't, and one can understand that if there was a good attempt at getting everybody there, yes, maybe it would comply. And I'll come back to to how that links in with Padja and Audi Alteram Partem. But just to complete on the notice issue, it's also dealt with by Prince Simakade in his replying affidavit. That's at paragraph 64 on page 054-35. I can read it to your lordship to save your lordship having to go there. Prince Simakade says, I too was not notified of the purpose of the meeting. Had I been notified, I would have been able to attend and to set the record straight when my letter of 11 May was misread to the meeting. Lord, again, I won't take you to the reference, but there was also the potential for confusion about the meeting, given that it was also the cleansing ceremony. So that also doesn't help. If one juxtaposes that on top of an already inadequate notice, one is running into legal problems. Lord, I'll come back to the letter of the 11th of May, but let me just briefly refer your lordship to the judgment of the Supreme Court of Appeal in Mpepu. That is in the bundle of authorities which are at 069 on case lines. And if I can refer specifically to page 758. The court will bear with me. My technological problems have momentarily returned, but I'll resolve them quickly.
Zero 6 9
758. Lord, that is the judgment of the Supreme Court of Appeal in Mpepu, and I won't belabor my way through all the paragraphs, but if one looks at paragraphs 16, 17, and 18, what emerges from that judgment is that ultimately both the identification decision and the recognition decision amount to administrative action. Yes, the identification decision cannot be reviewed separately and prematurely. The process has to be completed, but once it's completed, the entire process is recognized as being one of administrative action. And that has consequences for the way that both of those processes are conducted. Now, Lord, that decision of the Supreme Court of Appeal was confirmed on appeal to the Constitutional Court. That we will upload this evening, Lord. We don't. That isn't on case lines at the moment. But I don't plan to go to any specific paragraph. It was the judgment was upheld. It was a judgment given without a hearing, so it's held. It's quite brief in upholding it, but it certainly does uphold it. Lord, just while we are here, one aspect I would refer to, because it addresses an issue that was raised with by your lordship with my learned friend. one looks at paragraph 17 on page 069-763, in the fourth line, it says, pending the decision to recognize, the President or the Premier is obligated by the Framework Act to ensure that the identification process complied with customary laws, custom, and processes. And we say that the implication of that is it doesn't matter in a way whether or not there was a perfect identification process for the President to be able to assume a jurisdiction under Section 8.4. In fact, he has an obligation to check it out. And if he finds that it's wanting, as they say here in terms of customary law, but we would add to that in terms of statute and compliance with the statute, that is the time for him to act under Section 8.4. It doesn't deprive him of jurisdiction. It, in fact, confers jurisdiction upon him and obliges him to act. But, my Lord, I want to come back to the meeting of the 14th of May, juxtaposed against the requirements of Mpepu. Lord, Section 33(1) of the Constitution and Section 3 of Paja require that administrative action is procedurally fair. Lord, this is raised as a review ground in the founding affidavit at paragraph 5.2, just to give your Lordship the reference, page 002-13 to paragraph 220, 002-37. But what we say is because both of those decisions amount to administrative action, there has to be compliance with the requirement of procedural fairness in terms of Section 33(1) of the Constitution and Section 3 of Paja. Now, Lord, procedural fairness requires in the main two elements, a fair hearing and the absence of bias on the part of the decision maker. Both of these requirements of procedural fairness require the decision maker not to make up his or her mind before the hearing. If the decision maker prejudges the matter, he or she is biased and also does not afford the affected party a fair hearing. The sequence of events and Principal Telezi's own minute of the 14th of May demonstrate irrefutably that this is exactly what happened at the meeting of the 14th of May. Lord, he is the decision maker. The meeting is the decision maker, and he's the meeting is, and he's running it. The meeting is, and he's running it. He's de jure or de facto, depending on the outcome of that debate. But whatever the case is, he's certainly entitled to attend. We've established he's part of the royal family. He's part of the decision-making process, and he leads it in a way that ensures that it's a fait accompli before the meeting has even got underway. So we say there's a failure on both those components of the requirements of procedural fairness, and it does have the consequence that the meeting is biased. There is no chance that any competing contender can have a chance the moment that that Prince Misuzulu is introduced as the king.
You think no one can stand up to say that that isn't so? We haven't decided yet.
Well, Lord, not with a person.
Was it influenced such that when he makes the announcement, then you say that amounts to a prejudging of the decision maker, meaning the whole of the body of those attending?
Indeed, my Lord, he is a person of, one can take judicial notice of it, a person of enormous influence in our body politic. He's a person who's taken the bull by the horns as far as this process is concerned. There doesn't seem to be any debate about that. In fact, he asserts his right to do it. He's the one who leads it. If he wanted to ensure that that meeting was not biased and gave rise to a fair hearing, he should, in that capacity, have presented a neutral, objective presentation of the situation. These are the potential candidates. These are what favor him. These are what do not favor him. These are the criteria according to which, in customary law, we judge them. This one relies on ukufakwe eseswini. This is what ukufakwe eseswini means, as far as I understand it. Anybody in the meeting is welcome to say something in contradiction to me. And so on. He's welcome to raise the letter of the 11th of May. But don't do it as the minute clearly shows. The minute shows that he put in let me come to the 11th of May letter, because that also is a reason why there was a failure of administrative justice at that meeting. Lord, the other requirement of PAJA is adequate notice of the nature and purpose of the meeting. Adequate notice of the nature and purpose of the meeting. We have a minute that says the purpose of the meeting is to introduce the king. That is not compliance with section 32B1 of PAJA, which requires adequate notice of that purpose. In fact, people were completely misled as far as that was concerned. Lord, we say on that basis alone, the identification decision cannot stand. But if I can then move to the letter of 11th of May. Lord, the sequence of events is described in the founding affidavit from paragraph 121. It's 002-58. He says the following: I was not involved in or consulted about any of the foregoing developments at the instance of Prince Buthelezi. I knew that the customary procedures for identifying a new king had to take place and were taking place, and I assumed everything was being done lawfully in this regard. I did not participate in any meeting of the royal family to deal with the issue of succession, although I attended the subsequent meetings of 23 May and 5 September. I highlight in this regard that recognition of the successor is not a matter of voting or candidature, but a matter of the proper application of customary law. While I was trying to come to terms with events and following upon the announcement in the press and the press coverage, I received a barrage of calls from the media, supporters and other members of the public. I preferred not to deal with the media. I therefore decided that it was in my best interests and those of the Zulu nation to ask Prince Buthelezi to intervene with the media, given his function as spokesperson on certain matters affecting the Zulu nation. I therefore decided to address a letter to him. On the 11th of May, and against this background, I addressed correspondence to Prince Buthelezi indicating my intention to abide what I understood to be the decision of the royal family. I quote this letter in full as it has respectfully been misused and misinterpreted against me. And we then set out the letter at paragraph 124. Greetings to the Prince of Kwapindangeni. Mageba, I request the Prince to read this open statement on my behalf as it is. I am aware, Mageba, that my name is mentioned in some narrative that I, Simakade Jackson Zulu, have ambitions of ascending to the throne. I was thrilled when I saw the Prince stating on television that I've never told him that I covet this position, and I confirm what he said. I can confirm that I have not told anyone that I covet this position. I'm aware, Mageba, that there are rumors suggesting that there may be people who wish that I should take this position. I cannot do anything about other people's feelings. I want to state that my aunt, the princess, who is married to the Ndlovu family, and the prince of the Kwezi house, have advised us as the king's children that if the king or the queen chooses one of us, the one who is nominated should accept the nomination. Therefore, I would have accepted the nomination had I been selected. And they had also advised that we should accept and support whoever is nominated. As a respectful child and a humble person, I confirm that I will not disobey the words of our elders, as I have stated in relation to the above-mentioned pieces of advice. I request the Prince, as he reads the statement in its unaltered state, to ask the journalist to desist from calling me about this matter, because there is no further information I can give in addition to what I've already stated. Thank you, Mageba. It is me, your grandnephew, Prince Simakade Zulu. I emphasize that I wrote this letter in the past tense on the assumption that a proper process, both statutory and customary, had been followed, and that the outcome which I was bound to accept if the process was properly conducted was that Prince Misuzulu had been anointed as his Sidel. Had I known what I subsequently discovered to have happened, i.e. that neither the correct customary nor the correct statutory process had been followed for the appointment of Prince Misuzulu, I would not have sent the letter, at least in the form that it was. As the letter clearly conveys, if there had been a proper process and I had been nominated, as I ought to have been, I would have accepted my nomination to the position of king. And that is exactly what the letter says. He says, therefore, I would have accepted the nomination had I been selected. And they had also advised that we should accept and support whoever is nominated. This is a respectful person. When he talks about not coveting a position, he's not renouncing it. He's saying, I respect the traditional process, and I've been told to respect the traditional process. We mustn't be ambitious. We must accept the outcome of what the royal family, and particularly their elders, decide. Now, my Lord, against that backdrop, it's important to point out that his explanation, yes, if we look at Prince Misuzulu's affidavit, he has his own interpretation of that letter, very conveniently leaves out any analysis of the paragraph that I've emphasized. But there's nothing there to contest the thought processes that motivated Prince Simakade in the writing of that letter. And we set out in our supplementary heads at paragraphs 85 to 87, that's at 062-46. The legal principles as far as waiver and renunciation are concerned. First and foremost, it's a matter of intention. The starting point invariably is the will of the party that is said to have waived the right. Paragraph 85.2, Prince Simakade has explained in his affidavits that the letter of 11 May was never intended to be and objectively is not a disavowal of any claim to the throne. And then we quote the paragraph I've emphasized, 85.3. The knowledge and appreciation of the party alleged to have waived is furthermore an axiomatic aspect of waiver. Yet, as Prince Simakade explained in his affidavits, he wrote that letter under the misapprehension that a proper identification process had been followed. I mean, he'd been told that he'd been told himself that his mother had nominated somebody else. That was the fact that he had to try and come to terms with. Next page, 85.4. No one is presumed to waive his rights, and as a consequence of that, the onus is on the party alleging waiver to prove it, and clear proof is required of an intention to do so. The conduct from which waiver is inferred, so it has frequently been stated, must be unequivocal. That is to say, consistent with